Bryan Kohberger, the suspect in the brutal stabbing of 4 University of Idaho students, is facing a long and complex legal process that could end with his execution. In this section, we will explore some of the challenges and strategies that both the prosecution and the defense will have to deal with in this high-profile case. First, let's talk about the grand jury indictment. A grand jury is a group of citizens who hear evidence presented by the prosecution and decide whether there is enough probable cause to charge someone with a crime. Unlike a trial jury, a grand jury does not determine guilt or innocence, and its proceedings are secret and one-sided. The defense does not have a right to be present or to cross-examine witnesses. In Idaho, a grand jury indictment is required for any capital offense, such as first-degree murder. This means that before Kohberger can be tried for killing Kaylee Goncalves, Madison Mogen, Ethan Chapin and Xana Kernodle, he has to be formally accused by a grand jury. This happened last week, when a Latta County grand jury returned an indictment with 4 counts of first-degree murder and 1 count of burglary against him. The indictment is a significant step for the prosecution, as it means they have convinced at least 12 out of 16 grand jurors that there is sufficient evidence to proceed with the case. However, it does not guarantee a conviction at trial, where the burden of proof is much higher. The prosecution will have to prove beyond a reasonable doubt that Kohberger committed the murders with premeditation and malice aforethought, or with another aggravating factor that makes them eligible for the death penalty. One of the main pieces of evidence that the prosecution will rely on is DNA. According to court documents, investigators found Kohberger's DNA on a leather knife sheath that was left on Maddie Mogen's bed. They also matched his DNA to trash that was collected from his parents' home in Pennsylvania, where he was arrested after a 6-week manhunt. The prosecution will argue that this DNA links Kohberger to the crime scene and shows his intent to kill. However, the defense will likely challenge the validity and reliability of the DNA evidence. They may question how it was collected, stored, tested and analyzed. They may also raise alternative explanations for how Kohberger's DNA ended up on the knife sheath or in the trash. For example, they may suggest that he had visited or lived in the house where the murders occurred before, or that he had lent or given his knife to someone else. Another challenge for the prosecution is motive. So far, authorities have not disclosed why Kohberger allegedly killed the 4 students, or if he had any connection to them. The lack of motive may make it harder for the prosecution to convince a jury that Kohberger acted with premeditation and malice aforethought, which are required elements for first-degree murder. The prosecution may try to establish a motive by presenting evidence of Kohberger's mental state, history, personality, or behavior before or after the murders. The defense may also use motive as a strategy to cast doubt on Kohberger's guilt or culpability. They may argue that Kohberger had no reason to kill the students, or that he was suffering from a mental illness or impairment that affected his judgment or ability to control his impulses. They may also present evidence of Kohberger's background, education or character to elicit sympathy or understanding from the jury. One of the most unusual aspects of this case is that Kohberger has not yet entered a plea. He has remained silent at his arraignment and at his previous court appearances. This is a rare and risky move by the defense, as it means that Kohberger has not formally denied or admitted to the charges against him. It also means that he has waived his right to a speedy trial and other procedural protections. The defense may have chosen this strategy for several reasons. One possible reason is that they are waiting for more information or evidence from the prosecution before deciding how to plead. Another possible reason is that they are trying to avoid triggering certain deadlines or consequences that come with entering a plea. For example, if Kohberger pleads not guilty by reason of insanity, he may have to undergo a mental evaluation that could be used against him by the prosecution. However, this strategy also has drawbacks for the defense. By not entering a plea, Kohberger may appear uncooperative or defiant to the judge or the jury. He may also lose some opportunities to negotiate with the prosecution or to challenge some aspects of their case. Moreover, he may face more pressure from the prosecution to plead guilty or face the death penalty. The death penalty is another major issue in this case. Idaho is one of 24 states that still have capital punishment on their books, and one of 11 states that have carried out executions since the last person executed in Idaho was Richard Levitt in 2012, who was convicted of murdering and mutilating a woman. In the decision to seek the death penalty rests with the prosecutor, who has to weigh several factors such as the nature and circumstances of the crime, the impact on the victims' families and society, and the cost and resources involved in pursuing a capital case. The prosecutor has not yet announced whether he will seek the death penalty for Kohberger, but he has until 60 days after arraignment to do so. If the prosecutor decides to seek the death penalty, he will have to prove at least one statutory aggravating factor beyond a reasonable doubt during a separate sentencing phase after trial. Some of these factors include killing more than one person in one criminal episode, killing someone while committing another felony such as burglary, killing someone in an especially heinous, atrocious, or cruel manner, or killing someone who was under 14 years old. The defense will try to prevent or avoid the death penalty by arguing that there are no aggravating factors present in this case, that there are mitigating factors that outweigh any aggravating factors, or that there are constitutional or legal problems with imposing or carrying out capital punishment in Idaho. Some of these mitigating factors may include Kohberger's age, mental capacity, lack of criminal history, remorse, cooperation, family background, education, employment, community service, religious beliefs, or any other aspect of his character or record that could justify leniency. Some of these constitutional or legal problems may include racial bias, geographic disparity, arbitrariness, proportionality, reliability, innocence, ineffective assistance of counsel, cruel and unusual punishment, due process violations, international law violations, or any other issue that could challenge the validity or morality of capital punishment in Idaho. As you can see, Bryan Kohberger faces many legal challenges and hurdles in his case. He also faces many uncertainties and risks as he awaits his fate in court. His defense team will have to work hard to defend him against the charges and possibly save his life. His prosecution team will have to work hard to prove his guilt and possibly end his life. And his jury will have to work hard to weigh all the evidence and make a fair and just decision.